Welcome back to The Explainer. Today, we are diving into something really fascinating, the complete life cycle of Hindu marriage. We're going to look at how it went from this ancient, totally unbreakable spiritual bond to the highly structured legal framework we have today. It's honestly a perfect example of how laws just naturally adapt to fit a changing society. So let's jump right in and break down exactly how this whole thing works.
Real quick, here's our roadmap for today. We'll start with that big shift from sacrament to statute, run through the absolute rules for a valid marriage, and figure out what makes a union void versus voidable. Then, we'll look at the evolution of divorce, explore a few other matrimonial reliefs, and finally, step inside the modern family courts.
All right, Section 1, Sacrament to Modern Statute.
To really understand family law today, we have to look at where it started. We've seen just a massive transformation over the centuries. Back in the ancient period, marriage was considered sacred, permanent, and literally indissoluble. You just couldn't break it. But then, moving into the medieval period, things shifted. We unfortunately see a rise in highly patriarchal practices along with child marriages. Fast forward to the modern period, and everything changes again with the Hindu Marriage Act of 1955. This act stepped in, codified the rules, and brought in some seriously sweeping modern reforms.
Now, what's really interesting about this is the stark contrast between those two worldviews. I mean, the ancient view saw marriage strictly as a permanent spiritual bond. You were getting married to fulfill your religious duties, your dharma, and to continue your lineage, right? There was no concept of just walking away. But the modern view, it shifts all of that into a legal relationship. Sure, it's still deeply sacred to many people, but legally it's governed by a statute with enforceable rights, and crucially, it permits divorce.
And just to show you how detailed those ancient texts actually were, they recognized 8 distinct forms of marriage. 4 of these were approved, like the Brahma form, where a daughter was given to a learned man. But then there were 4 unapproved forms, and if you look closely at that unapproved list, you'll spot the Gandharva form, which was based entirely on mutual consent or love. So, kind of playfully speaking here, a modern love marriage is basically the ancient unapproved Gandharva form. The others, well, they ranged from outright purchasing the bride, that's the Asura form, to completely condemned exploitative practices.
Okay, let's move on to Section 2, Rules of a Valid Marriage.
So the crucial point here is that under Section 5 of the Hindu Marriage Act, there are 5 non-negotiable legal requirements to make a marriage valid today. First up, monogamy. Neither person can have a living spouse. Second is soundness of mind, meaning both people are fully capable of understanding what they're getting into and giving valid consent. Third is the marriageable age, which is currently 21 for the groom and 18 for the bride. And finally, the couple has to fall outside of prohibited relationships and outside of what the law calls sapinda relationships.
Now let's clarify that last one, because it's specific. A sapinda relationship is essentially a familial bond based on shared ancestry. The law strictly prohibits marriage between sapindas, mostly to prevent genetic overlap and maintain social structure. But there is a really fascinating exception built right into the law. If a specific community has a custom that actually permits it, and they can prove that custom is ancient, certain, and reasonable, then the marriage is perfectly legal.
But you know, even with all these modern statutes, ancient ceremonies still carry massive legal weight. Take the Saptapadi, for example. That's the essential ceremony of taking 7 steps around the sacred fire. Legally speaking, the marriage is only complete the exact moment that 7th step is taken. In fact, in the famous case of Barao Shankar Lokhande, the courts highlighted that customary ceremonies like the Saptapadi are absolutely vital to the sacramental nature of the union. Moving right along, Section 3, Void or Voidable.
Okay. Let's dive into what happens when the rules are broken right from the start. There's a critical legal distinction you need to know here. Section 11 covers void marriages. These are literally null from the very beginning. So if someone commits bigamy or marries a close sapinda relative, in the eyes of the law, that marriage just never existed at all. On the flip side, Section 12 outlines voidable marriages. If a marriage involved fraud or coercion, it actually remains a completely valid marriage until one of the parties takes it to court and gets it officially annulled.
To protect against a lot of these messy disputes, the legal system relies really heavily on documentation. The Supreme Court emphasized this exact point in the landmark case of Seema v. Ashwani Kumar. Basically, registration provides ironclad proof of the marriage, prevents disputes down the road, and helps enforce legal rights. Now, failing to register doesn't automatically invalidate your marriage, but having that certificate, that's your ultimate legal shield.
But that brings us to a really pivotal question. Say you've met all the legal criteria, you've done the Saptapadi, and you are officially registered. What happens if a legally valid marriage is just essentially over?
That leads us into Section 4, the evolution of divorce.
Keep in mind, dissolving a marriage was practically unheard of in Orthodox Hindu law, but today, the law accommodates the end of a marriage through 3 distinct theories. First up is the fault theory. That's invoked when one spouse commits a recognized matrimonial offense, like cruelty, adultery, or desertion. Then, you have the breakdown theory, where the courts simply recognize that the relationship is irretrievably broken no matter who's at fault. And third is the mutual consent theory, where the marriage is dissolved simply because both parties agree to end it.
Let's move to and see how this builds into the specific rules for a mutual consent divorce under Section 13b. The law requires a deliberate step-by-step process so people don't just make rash decisions. Step 1. The couple has to have been living separately for a full year. Step 2. They must mutually agree to dissolve the marriage. And Step 3, they have to prove to the court that there is an absolute inability to live together.
The legal system is actually becoming incredibly pragmatic about the reality of these broken relationships. Take the significant case of Naveen Kohli v. Neelu Kohli. The Supreme Court explicitly recommended that the legislature formally recognize the irretrievable breakdown of marriage. It just goes to show this modern trend of courts acknowledging when a marriage is practically completely broken rather than forcing a hollow legal shell to stay intact.
Section 5, other matrimonial reliefs.
Now, divorce isn't the only option. The law actually provides a few other ways to navigate a struggling marriage. Judicial separation under Section 10 is super interesting. It lets parties live separately without actually ending the marriage legally. Think of it as a structured cooling-off period designed specifically to encourage reconciliation. Then there's repudiation. This protects young women by allowing a wife who is married under the age of 15 to legally repudiate or reject the marriage before she turns 18. Finally, we have the restitution of conjugal rights under Section 9. Basically, if one spouse withdraws from the society of the other without a good excuse, the court can legally order them to resume cohabitation.
I know, a court ordering a couple to live together might sound a bit intense, especially today, but the courts hold the preservation of marriage in incredibly high regard. In the case of Saroj Rani v. Sudarshan Kumar Chadha, the constitutionality of this restitution of conjugal rights was firmly upheld. It really demonstrates that the legal system still views marital duties and saving the family unit as absolutely vital social priorities.
And finally, Section 6, inside the family courts.
And this brilliantly illustrates where all these legal battles and reconciliations actually happen. The Family Courts Act of 1984 established spaces that are totally different from standard civil or criminal courts. They are deliberately conciliation-oriented, meaning the main goal is to encourage settlement and try to save the relationship if possible. They use a highly simplified procedure, making things way less technical and much more accessible for the average person. They conduct proceedings behind closed doors, in camera, to fiercely protect family privacy. Plus, they handle everything in one place: disputes, maintenance, guardianship, and child custody. The whole shebang.
Now, to do all of this effectively, these courts need serious, wide-reaching authority. In the case of K.A. Abdul Jalil v. T.A. Shahida, the Supreme Court reinforced that family courts hold exceptionally broad jurisdiction, because it's not just about applying rigid black-and-white rules. It's really about ensuring specialized justice that actually protects the dignity and the overall welfare of the family standing in front of the judge.
So, we've seen how Hindu marriage has transformed from this unbreakable ancient sacrament into a modern statutory right, completely shaped by landmark rulings in these specialized courts. Which leaves us with a final thought to chew on. If modern law perfectly balances individual liberty with family preservation right now, what will the next evolution of marriage look like? How are future shifts in society going to continue shaping these ancient yet modern laws? It's definitely something to think about. Thanks for joining me as we unpacked all of this here on The Explainer. Keep learning, and I'll catch you next time.